What's up, kings and queens? I will be live as soon as I see around 20 people will be coming through. Anyway, we're going to talk about the excellence of this lady that you see on the screen right now. She was just, bouncing, crashing the NPA today. Join me guys later as we discuss how brilliant and concrete this lady's argument was. I've got a few clips as well. In fact, I'm going live right now. I'm not going to waste your time, guys. We in, guys. What's up, kings and queens? What's up, kings and queens? We're back again. Please like the live. Please hit that notification bell so that when we drop more content like this, you are in the loop. What we are going to discuss today is something that I missed yesterday, right? When Mr. Ndlovu, who was on the stand, he talked about using snipping tool. You know, snipping tool from Windows and stuff like that. He used that to cut off pieces of the whatever that he wanted from the photograph, right? That's what he used. So I'm just perplexed. Yeah, man. I didn't want this one with letters on it. Yeah, I think I'm cool. Now, this is what he did, Mr. Ndlovu. He said he used a snipping tool. So my thoughts are, if he used a snipping tool, what does that mean? Does that mean now the photos that he presented after that photo that is a product of a snipping tool, what do we call it? Is it, it's not original anymore, right? I hope you understand. Let me just play a little clip of those proceedings of yesterday as he was talking about this. Then we'll take it from there, right? Very funny. Some of the things that are happening in the state's case. Wow, very funny. Let's see this thing, guys.
Then once I have cut that into this page, I brightened it or lightened it to be more clearer using the Office Word.
Office Word. Ngitheke sengikwenzile ke lokho ukuthi ke aqhameke noma ke akhanye ngenza ke ukuthi.
Let me just take it back a little bit again. He's using like alteration tools.
Triathlon, the ultimate test of endurance, commitment, and right now,
Thank you for that. Now I see these pictures. It's one picture, but it appears on different lights. Can you explain to the court the process in which you used to shade them with different lights?
Ngiyabona ke isithombe sodwa kodwa ke kunama line ke ahlukahlukene uma ungachaza ke uhlela noma indlela abenze ngayo ukuthi ke abe khona ke kulama lines ahlukile.
I used a simple snapping tool from the computer to cut from the original picture.
Let me just pause it right there. You hear him now. He said he's using what? A snipping tool. From what? From the original picture. So that basically means this is not the original picture anymore. This tool is now, like this photo is now the one that is coming from the snipping tool. It's something else. So, like, these guys are blatantly altering these pictures, and then they expect these pictures to be accepted as pure, honest evidence by the courts. Now, my focus of the day, like today, I really want to focus on this lady, right? This lady, she showed us black excellence. I was just impressed. I was just hell over impressed, right? This lady, she is that lady who is representing Charlotte, right, in that extradition case. Wait. Yeah, that's the lady. Now, I want you to listen to the NPA claiming that they are going to appeal the case. They are going to look into the grounds of what to do to win the appeal, right? And then you listen how boisterous and how confident this guy is feeling like before today. Because today, that case went on, and then they lost. The NPA lost, brutally so, because of the brilliance of this lady. Where is Jasirata talking about black lawyers? There's no black excellence. Wow, man, this lady was on par. Now, let's listen to the NPA talking about they are disappointed because they just lost that extra, because they didn't follow the law, right? It's supposed to be coming from the minister, that extradition order, but they decided to do it via their prosecutors, right? Now, the nice part about this is this lady, advocate Loyiso Makapela, right? She's destroying 2 white advocates for the state who are sitting next to her. Let's listen to this, the NPA representative complaining. Please like the live, guys. Please like the live. Also, hit that notification bell if you are not subscribed. Subscribe before, and then hit that notification bell so that I will notify you when we drop more content. Now, let's take a listen to this guy complaining.
Because you'll recall the view that we held, that it was more of an appeal in South Africa on a foreign state judgment in circumstances where they had not utilized or explored the appeal processes in the United States. However, because it is a judgment that has the effect of a final order, we are allowed or permitted to appeal it. But at the moment, we'll have to regroup as a team and reflect on the judgment and see if we can identify grounds upon which the judgment could be appealed, given its impact.
You say that it was an appeal of a judgment that was handed down in the US, but we did not hear any of your prosecutors saying that
performance
to the judge or pleading that before the judge. What they did was try and defend their conduct. What are your thoughts around that?
Of importance is the fact that the feeling from the team was that the conduct was above board in the allegations that were made against the investigating officers. Unfortunately, the judge found otherwise, and therefore it is one of the issues that we'll have to reflect on. If we find a basis which we're allowed to, that the judgment could be appealed, that determination will be informed by that process. What is important for now is to reflect on it, process it, because like I said, it is a judgment that has the effect of a final order, because we cannot charge her now unless the decision is overturned by a higher court in the event that we take a decision to appeal it.
The judge also found that the procedure in which this extradition was done, it was the executive that was supposed to spearhead this procedure, but the NPA seemed to take charge over all of this. Does the NPA take accountability because of those flaws that happened? Also the misrepresentations, the lies that happened, does it take accountability that it was at fault? This is what led to this basically Ms. Cholota going scot-free now.
Now, just listen to this guy if he's going to take accountability. Do you think he will? Never. Because, of course, today they came up with that appeal, in fact, application to appeal, which was denied. Because that lady, you're going to hear her. I have clips of her as well when she was dropping those arguments. Wow, man. She's on top, like concrete submission. And she's even like, man, it's not hard to understand what she's trying to put on the table. Like, you take it from there and then you feel it right now. Now, let's listen to this complaining guy from the NPA, and then we'll go to that lady.
There are two ways I'm going to answer that question. One, if you're saying we must take accountability for the findings made by the judge in circumstances where I make it clear that we'll still reflect on the judgment and see if there are grounds to appeal it, it's not fair. The second part of it, the judge made reference to the Schutz SCA judgment. That judgment, for the record, we have filed an application for leave to appeal against it in the Constitutional Court, albeit on a limited grounds. So we are going to take into account that technicality to see to what extent does it have a bearing on what we would have an appetite to appeal the judgment or not.
It's not going to happen the way he is wishing it could happen. First of all, they don't want to take accountability that they didn't follow the right procedure. And then the argument in court now is what Ramasipili called laughable, because they are talking about it's an argument of law, like the rule of law or something like that. And the other lady is telling them no, even if it was, still this judgment of scholars that they're talking about, it was already made. And whatever appeal that they're talking about, that they say they were going to lodge there, she told them straight in their face, you don't have that appeal. You haven't got it. So until you have that appeal, you could say it. But that appeal is going to come later when we're already done with this process. This lady's killer. Let's take a listen, guys. Gonna take it right around the middle when she's nearly finishing. But even at the back there, I just suggest you go and check it out. Even at the back, at the beginning, and she's crashing. Let's take a look.
Really indeed is true, because there was no overlooking of anything by the court, because the state never placed anything before this court. Now, then, my lord, the rest of the application goes on about how the Schultz judgment was the only reason that this court came to its decision, and the fact that that happened is in fact a question of law. That is also a question of fact. Because if my lord came to its decision using a particular judgment, that's a question of fact, that's not a question of law. A question of law would be where the court incorrectly applied the legal principles in that case. And I do not understand that to be the state's case, that my lord incorrectly applied the principles in Schultz. If that was the case, that would be a question of law. But the fact that my lord relied on Schultz in order to state the legal position as it stood, that is a question of fact. My lord could have used the Extradition Act and relied on that. That would have been a question of fact as well. It would have only been a question of law if my lord did so incorrectly. And in our response, or opposition rather, to the state's case, one of the things that we state is that the discretion, according to all the cases that we cited, and we cited quite a few. We cited S versus Khoza and Anara, that would be at page 2, as well as Attorney General Transvaal versus Kada. And in those cases, they say that Section 319 does not find application where a question of law is in reality a question of fact. That is what the state's case boils down to. Just because they claim, or they are of the view that it is questions of law that they have in this application, does not necessarily make that questions of law. And
did you know that AI trading systems can enhance your trading ability?
And just because they use the word legality in their oral arguments does not mean that that is what their application is based on. In fact, there's nowhere here where I see legality. And where an example of this would suffice would be where the state, their case was that it is the NPA that is clothed with the authority to make extraditions and not the executive. If that was the assertion, that would be a question of law, and that would have been them raising legality. But that is not their case, my lord. Nor do they state that that position is incorrect in any way, shape, or form. They maintain their arguments on Schultz.
I just want you to watch that white lady there sitting down the wall. Look at her. To me, it's like she's looking at her. It's like, give me your brain. Please give me your brain. You are so gifted. Oh my God. She's crushing it. Let's continue.
But Schultz said that the NPA does not have the power to make or request extraditions. It is the NPA. They do not find fault in that. But they find fault in the fact that my lord used Schultz to come to the decision that the extradition is unlawful for want of a valid request for extradition. Those two are counterintuitive, those two lines of thought. It's either the state is saying to this court that the question of law is that the NPA is clothed with the authority and not the executive. That is a question of law. And saying that my lord's reliance on Schultz is incorrect then, because Schultz states that it is the minister that has authority. But they do not say that. And so simply because they state there's a question of legality here, there's no question of legality that I was able to see in any of these pages. And then we state, we quote S versus Basson. And in S versus Basson, and we quote this at page 3 at the very top, it says there, the state has no right of appeal in terms of the act against incorrect factual findings by a trial court. The state can appeal only if the trial court gave a wrong decision due to a mistake in law. Nowhere in the application is there any mention made that this court committed a mistake in law, nor do they identify what that mistake would be. They appear to agree in the paragraph that I just read previously in the application that the court was correct in its application or its understanding of the doctrine of legality, and that the court was correct in its application of international customary law. And so if we accept that, then it cannot be that this ruling was a mistake in law, particularly when the state has not identified what mistake in law that could be. We then look at, or we then cite Dutoit's commentary, my lord, and we underline in the middle of page 3, where it says, furthermore, if the alleged question of law is nothing more than a question whether the judge had correctly considered the facts, this remains a question of fact. Now, this would be the case if the state, during the trial within a trial or during oral arguments during which we raised the Schultz matter, my lord, had come up and said to this court that, my lord, we wish to point out to this court that the Schultz matter is in fact before the Constitutional Court, and as a result, its operation has been suspended. If my lord had then overlooked that submission, that would be an error of fact still. But that was not what happened. They did not bring that to this court's attention. The first time we heard about the Schultz matter being on appeal was when the NPA spokesperson stated in the media directly after court proceedings. It then became their leg to stand on to bring this application for a reservation of a question of law. And even then, they do not bring this court into its confidence to say, when was this appeal reinstated? Because they accept that they filed it 4 months out of time. Then they accept that it was withdrawn in February 2025. That is public knowledge. It was stated by, I think, the head of the NPA. And so when was it reinstated? They do not tell.
I want to add a few words. So it basically means at the NPA, there's a lot of problems there. And they have this tendency of presenting cases that they really like, they waste money, present that case and arrest somebody, take action, even when they are not sure that they're going to win it. They will do that. They will just go out of their way and try to win a case that is not winnable. It's amazing that now, Rata is always saying black lawyers for blah, blah. Now, these are white people from the state prosecutors who are presenting the case for the state. They are white, but still, it doesn't become any better. It doesn't like they don't come up with any improvement. They don't add any enhancements to like the procedures. The procedures should have been followed, but they did not. They just followed their feelings, and then now this lady's out. They can't touch her. Even today, the judge ruled that, I'm going to show you that clip, the judge ruled that no, it's not possible for them to touch her, and it's not possible for him to reinstate that appeal case that the NPA is talking about. Right, let's continue, guys.
Tell us at all, not in oral arguments nor on their papers. And so it can only be that it has not been reinstated, and that the assumption by the state is that it could bind this court to an intention that the NPA has to reinstate an application. That cannot be. That's wrong in law. That's wrong in law. We're not bound by their intention, nor is the law suspended or its operation suspended simply because they say they've got an intention to go to the Constitutional Court. We then, my lord, relied on the Mahmoud judgment at page 5, and there it was about the remoteness of the application, or rather the applicability of it. So in other words, if this Schultz judgment were to indeed be before the Constitutional Court, would that take away the legal position? No. And so the reservation of the question of law is that remote, because it does nothing to the actual not consequences, the actual result of the case. The result still is that it is the minister that has the authority, and the result still is it was the NPA that made the request, and so the result will always be, regardless of Schultz, that was unlawful.
It's an innovative financial tool developed using artificial intelligence.
Wait, you mean it manages investments on its own?
Yes, the system automatically
Well, let's hone in on that story now. The NPA's application to approach the Supreme Court on Judge Philip Loeb's decision to rule Muradi Cholota's extradition from the U.S. has been dismissed. Ziniko Mhlaba is in Bloemfontein for us, tracking that story. And perhaps a good idea just to give our viewers some background to the story, Ziniko. Muradi Cholota, the former PA to former Free State Premier Ace Magashule, she would have been part of the accused in the asbestos corruption case alongside Ace Magashule and several others.
That is correct, Michelle. Actually, the involvement of Mr. Cholota on this particular matter just started after she had appeared before the Zondo Commission, where she was invited to testify before the then Deputy Chief Justice Raymond Zondo. And following that, there was a letter that was sent to her as she was still in the USA pursuing her studies. And of course, the first approach the state used in terms of trying to interact with her, they had approached her citing that she might be one of the state witnesses. And of course, after the first interaction with the NPA, and of course, Ms. Choloto then, according to reports, failed or refused to implicate individuals on facts she was not aware of. That's when then the attitude of the NPA towards her changed, and then now she was approached as a suspect. That's how she was linked to the asbestos matter. And of course, what we understand to have been the core of the argument or her involvement was that the core of the involvement of her in this particular case, it was in her capacity as a personal assistant to the then former premier of this particular province, as she was a personal assistant. So the NPA or the state at the time wanted to understand what exactly was happening through the bursary schemes, and of course the involvement and the transactions that were happening from the office of the premier on the matters we are dealing with today. And that's when it all started for her. However, then there were several attempts which were made by the state to try to bring her back to South Africa. I understand 6 times they tried, and obviously in the very last time, that's when they added new information which then described Michelle.
And we're expected to respond before the court closes. And one can tell that their intention was that we won't be able to respond before the close of court yesterday. But surprisingly, we were able to do so. And that's why we are here today. And that's not the manner in which we ought to deal with each other. They have been long aware on the 3rd, and they mentioned on the 4th of this month that they are going to appeal this matter. One, it begs the question as to why we only served with the document only yesterday, and we.
That is the defense, right? It's not the NPA. So they're also pulling monkey tricks there. Same thing in the Miwa case. Same thing that Balu is doing. It's always happening like that. Wow.
Expected to be here today, but in any event, we are here and we have seen the judgment. But we are not surprised with the outcome. We have long been aware that the manner in which our client was extradited was unlawful. It's a settled law that the power to request an extradition or for someone to be extradited lies with the executive. So we believe that now the time is ripe for the NPA to take accountability. To an extent that they cannot do that, they need to leave our client alone.
I mean, talk to us about, I know you have not consulted with her just yet about the next step, or if you have, you
they really needed to leave his client alone. Now, let's leave this case alone. Let's go back to our normal case, our usual case. Now, you know, this state case, right? This state case, it is full of holes. Hey, news for sure. What's up, bro? One Love King. Now, the state's case, Baloy's case, Sibanda's case, and Gininda's case, it's full of holes. It's full of multiple holes. They have to keep patching up, you know, trying to come up with monkey tricks. And this dishonesty that this guy is talking about there, it's happening in the NPA of Baloy. They are always dishonest, bringing in late evidence, ambush statements and all that. They're always coming up with some, some monkey tricks. It doesn't help to try to prove your case when they are the ones who are supposed to prove that these guys are guilty. And then now the judge feels like he was talking like when that Friday process started, he said, this case is beset with people who think they know the law more than this judge. I was like, man, the actions that you are pulling, you are not gathering any respect for yourself. Anyway, yourself. Whatever you are doing there in court, it's not actions that says, no, I want respect. No. All those actions says, it makes people loathe you. People who really want justice. It makes them to doubt you. It makes them to judge you, to start putting assertions on your name. It's because they can see for themselves that, no, there's a problem here. This judge is always siding with the state, even though the state's evidence is poor. Everybody can see that. Every little argument that they are hanging on is based on what the defense is saying when they are denying whatever they're denying. They don't really have that concrete evidence that they can bring and say, yeah, you know what, this is what happened. We have your photos, and then we have Zungu. You was with Zungu. You don't believe you was with Zungu. Okay, we have Zungu's AVLs. You said you wanted Zungu's AVLs. Here they are. On the day that he said he was at Tembisa, here he is. But everything that they do, it's edited, chopped up. Look at these photos that they bring in now. Why didn't they bring the CDs? Why did some photos need to be cropped using snipping tool? Because snipping tool, when you use it, right, you obviously, let me just demonstrate a little bit of what I'm talking about. Snipping tool. When you use it, it's just gonna take that little bit of whatever that you are using, right? It's gonna take it, and this is snipping tool, right? Now the snipping tool, when you use it, let's say I want to take a screenshot or a piece of this guy's head. This is what happens. Snipping tools will do this. You see what I'm saying? And then you get a picture that you can save somewhere. Now, when you zoom into that picture, you have problems, because now that's when the blurring start to come in. That's when some artifacts start to form, some pixelation, like some out of shape things, right? Why not just you took out the picture? How did that picture come out from XYR? You took it out. Why don't you just put it there so that we can make our own comparison, looking at the whole picture? Why is there cropping? What is it that you're cutting out? That's questions that I have myself about that process that was happening. Snipping tool. When I had snipping tool, I was like, there's nothing original about these photos. If you were able to cut them out, No, there's nothing original. It's just means that you wanted to present the picture that you wanted to present. So now at this point, you can't discount the fact that there's some editing involved, even in that, like in the pictures themselves, the content of the pictures themselves. There could be some editing involved, provided if you had watched the pictures up until Mohane, and then after Mohane you don't know what happened. That means you don't know what happened after Mohane took those pictures from you up until they landed up in that diary, in that album that State was presenting lately. This is what's happening. So please, guys, like the live. I'm about to pop out. I just wanted to drop this, and I just wanted to say kudos to that lady, Mrs. Loyiso, Advocate Loyiso Makapela. She's a High Court judge. She was killing it, just showing that the state can be beaten. I just wanted to see that. It was a great feeling, because here we are struggling in this Mayor case. The judge is not doing what this other judge is doing, applying his mind and just being fair and just applying the law. No, he's telling us he knows the law, is applying the law, but obviously it is being distorted. Right. Another question that you ask yourself: if the state wants to prove that this guy has had gold teeth, why did they just in the beginning decide to just take one guy there, Ntanzi? The focus now have shifted from Ntanzi being the guy who was being the first one who was shooting and whatever. In fact, the second suspect who was shooting, it has now become something else. Since the doctor now said he's got no gold tooth, he never had it. So now it's somebody else. They are focusing on accused number 3, but they want to prove that with what? With edited photos. Photos that were pixelated, zoomed in just to make it bigger. And then when you make it bigger, obviously some things start forming there. So guys, please, let me not take too much of your time. I'm happy that I was live. At least I was live for about close to an hour or so. 44 minutes, not that bad. Anyway, guys, please like the live, hit that notification bell. When you know, make sure that when we drop this content, they let you know. And now, tomorrow, we're probably going to drop another live talking about strictly about the Mayor case. I'm just going to make some little research and find out what we can talk about. I'll post it so that we can communicate. Peace. One love.